welcome to all our listeners. And David, we wanted to understand today what really is the difference between adjustment of status versus consular processing.
So probably it's a great question and one that we get frequently from our clients, especially those who are thinking about bringing their loved ones to the United States. Oftentimes the issue of whether or not we're going to do consular processing or adjustment of status finds its genesis in whether or not the individual who we're applying for is in the United States who has good status. So oftentimes an individual might be a visitor. They might be in a non-immigrant B visitor status. Mm-hmm. An individual might be a student. They might be in a non-immigrant international student visa status. They might be an international worker, like in the H-1B. If they're in the United States and they have valid status, then what we're able to do is we're able to apply for adjustment of status in the United States, and they can convert non-immigrant visa status to usually a green card, right? So that's the first thing that we would look at.
So basically whatever visa they're on, trying to convert it to a green card status visa.
Correct. Correct.
Okay.
But the other option is for an individual to go to the U.S. consulate office abroad, and that is a different type of agency. And that's one of the things that's super important to understand, is that these are two different agencies that are doing these adjudications. If the individual is in the United States in valid non-immigrant status, then that adjudication is done before the U.S. Department of Homeland Security, or USCIS, which is the entity that we do a lot of our work with, okay? But if they're abroad and they are seeking to enter the United States with a green card, then they would go to the U.S. consulate abroad. They would consular process for that green card. So they would go for their interview there. They would go for their medicals there. They would go and have their biometrics done there. And then they would have the green card when they enter the United States. Okay, so some of the thinking that goes into it by immigration lawyers like ourselves is, does the individual need time to wrap up their affairs at home? Or if they're in the United States, can they stay in the United States while we apply for their adjustment of status? So that's one of the things that we look at. Another one is if they're in the United States and they need to get work authorization, we can apply for a work authorization document. The problem there is that it could take some time, sometimes anywhere between 6 months to 9 months before they can even get a work authorization card in the United States, although they're working slowly on the possibility of allowing for premium processing for adjudicating these employment authorization documents. So a lot of times, basically what it is that we have to decide whether or not we want to have a wait time at the consulate, or whether we can quickly adjudicate their cases here in the United States through adjustment of status.
Wow, thank you for shining the light on that. That's David Knockman, founder and managing attorney of the NPZ Law Group, immigration lawyer serving New Jersey, New York, and Indiana, with offices in India and Canada, helping you with everything from green cards, marriage, and H-1B visas. Call them today at 201-670-0006, or just log on to visas